Hi, I'm Guy Lewis. I'm a lawyer in the Litigation and Dispute Resolution Group here at McCabe Curwood, and I'm here to give you an update on an interesting decision that was recently handed down on costs. Justice Ball of the Supreme Court of New South Wales recently handed down an interesting and significant decision on costs in the matter of Donau Proprietary Limited and ASC Shipbuilder Proprietary Limited. The substantive proceedings concern Donau's entitlements to fees for the construction of various parts of warships for the Australian Navy. The practical result of His Honour's findings was that ASC was successful and that a substantive judgment was entered in its favour. The court invited the parties to make separate submissions on costs, and His Honour handed down his decision on the 23rd of October 2018. The usual position is that a successful party will be entitled to costs on the ordinary basis from the unsuccessful party. However, ASC submitted that a portion of its costs should be awarded on an indemnity basis because it made an offer of compromise to Donau that was ultimately more favourable than the order that Donau achieved in the hearing, and Donau had rejected that offer. On the other hand, Donau submitted that each party should bear its own costs for three main reasons. The first was that ASC succeeded on a case that was substantially different to the one that had actually advanced at hearing and from the one that formed the basis of its offer of compromise. Therefore, Donau said that ASC should not be entitled to indemnity costs. The second was that throughout the course of the proceedings, both ASC and Donau had incurred costs on substantive claims that were ultimately abandoned before the final hearing. And the third that was while ASC succeeded on its primary claim, it failed on its own cross-claim, which had taken up a significant portion of the proceedings. Justice Ball accepted Donau's submissions and ordered that each party bear its own costs. His Honour held that this was a practical way of apportioning the costs between the parties to reflect their relative successes and failures in the issues in dispute. There are two main take-home points from this decision. The first is the decision is a timely reminder of the court's discretion to make whatever cost order it sees fit, and of the limitations of an offer of compromise forming the basis of a party's entitlement to indemnity costs, especially when its success in the proceedings is not based on any case that it had advanced at the hearing. The second is that the court will apportion costs to reflect the relative successes and failures of the parties in the dispute, and that a practical way of doing so may be in order that each party bear its own costs. Thank you.